Welcome, students. We're on Chapter 6, which is General Partnerships. And typically, general partnerships are now regarded as one of the least favorable business entities unless the two partners or more are corporations that then form a general partnership. But you're going to see that there's some liability issues that would make this very unpopular as a business entity unless those parties were incorporated. Okay, so we have the chapter objectives, and those are for you to read and make sure that you're learning what you should be from the chapter. So I'll let you read those on your own. Okay, so there's two types of general laws across the country that have been codified by each state a little bit differently. And those two are the Uniform Partnership Act and RUPA, the Revised Uniform Partnership Act. So UPA and RUPA. We're talking about Oompa Loompas from Willy Wonka. That's one of the mnemonic devices I use for myself, the two acts, UPA and RUPA. Okay, so this older definition from the first act, UPA, is still good and we should still use it. And it's an association of two or more persons to carry on as co-owners of a business for profit. And this is really important because it has to, by definition, be more than two or two. And persons in law means natural or artificial persons. So a natural person is a person that you could actually touch. An artificial person is one that you can't touch, like a corporation. So this goes back to what I was just saying about the two corporations could be a partnership. They have to be carrying on, and that's also a legal term of art, and it means they're actively seeking new business. They have to co-own it, and it has to be for profit. So the goal has to make money. So typically nonprofits aren't going to do this. All right, let's go into the next slide. Okay, so nowadays the law that applies is RUPA. And this is a national suggested type of law that's codified by each of the states. So in the California Corporations Code, you'll often see these things codified there for the state of California. And that will be the law that applies in addition to the partnership agreement and then common law, which is case law under the state of California. And California is not a very a corporation-friendly state or a business entity-friendly state typically. So a lot of times people will try to go ahead and organize in another state. But with things like sole proprietorship, general partnership, and such, people usually stay within the law of the state of California. And if you get bigger, like a corporation, then you think about maybe Delaware or Nevada instead of California, because some of our laws are not very business friendly. Okay, so formation and financing. A general partnership is only slightly harder than a sole proprietorship to go ahead and form. You have to do some more paperwork, and if you have a fictitious business name, then you're still going to have to file that fictitious business name statement. And we're always thinking about those 8 types of paperwork we talked about earlier and whether or not this particular business entity will have to go ahead and file that. Now, in general partnerships, because you have more people than a sole proprietorship, which is just one, it is a little bit easier to get funding because you have more people's credit to rely upon. Okay, the public document in the state of California would be the Statement of Partnership Authority. And you would find that document on the California Corporations California Secretary of State website, along with most of the business entity paperwork for the state of California. And things that are going to be public knowledge are these items here: the partnership name, where the principal place of business or main office is, a registered agent. And a registered agent is really important with a business. It is someone that accepts all lawsuits on behalf of the business. So, for example, when I was one of Target's attorneys, we didn't want to get those lawsuits at Target, like in customer service. Occasionally people would try to serve Target there, but it's very bad for business. It's an employee demoralizing event. It's, customers don't like to see that. And so typically a business will have an attorney or a company that they have their lawsuit sent to, and that person or company accepts those lawsuits on their behalf. Now, the names and mailing addresses of the partners can be public knowledge, and that's a little bit problematic because a lot of people want to have their privacy. So again, the corporation, if they were a partner, they would have their corporate business address, and that'd be a little bit more protection for the partners. And then also it's going to state who has the authority to basically sign contracts on behalf of the general partnership. It's very important to know what goes into the public document versus the private document in business law and business organizations. It's the stuff that's in the public document we can talk about as paralegals and attorneys, but definitely the stuff in the private documents we need to keep private and confidential as their representatives. All right, so the private document is going to have, again, the names and addresses of the partners, where they work, but it's going to have more detail. It's going to have how much money did each partner put up. And if you can see your law firm's partnership agreement, it's really fascinating because, for example, I worked at one law firm where one attorney had all the money and the other one did not. And the attorney with all the money had a 51% vote, and the other attorney had 49%. So it was a good thing to know and a good document to read, because I always knew that attorney with the 51%. I had to listen to him a little bit more, if you will. All right, it talks about management. Who's going to manage? Are they going to manage equally? Is it going to be 51-49? When do the partners get paid, if ever? How to go ahead and change up partners, end the business. So a lot of the stuff that the partnership really doesn't want to be known publicly. Okay, so what can a partner contribute to a partnership so that they can become a member? And it's almost any type of asset. You can think of cash, a building, a car would be personal property. Intellectual property is ideas that are marketable. So like the secret sauce, if it was a restaurant. Work, contributing time to the partnership. And typically these items that are put into the partnership are not given back to the parties until the partnership is dissolved. If our partners want something different, we need to be very clear about that in a partnership agreement. Okay, so RUPA says that if it's not discussed in the agreement, or there is no agreement, all partners will manage equally. And that is even if they contribute a different amount. So that is not what people want oftentimes. Oops, sorry. Let's go back. So think about it this way. If you put in 100% of the assets, but you didn't have a partnership agreement, you'd only get to have a 50-50 vote if there are two of you. So a lot of times people really don't like that, and it's our job to make sure what they want is put into that partnership agreement. Typically in a partnership, we do want an odd number of partners, or we want that 51-49% split so that we don't have a tie that we can't break. And management really makes or breaks, management really breaks or makes a company. So for example, we have this grocery store that was a UK company that came into the United States. It's called Tesco, and it decided to just start up all these grocery stores. And it was an interesting business model. It was called Fresh and Easy. It had a lot of family pack food. It had a lot of quick and easy to cook at home food. But it also had a ginormous English section of food. So it had foods like spotted dick and Yorkshire pudding and these different types of food that in general the American public were not too used to. And it gave a tremendous amount of shelf space to this food. And it just hemorrhaged money because this company came into the United States and didn't really advertise much before it got opened. It gave a lot of shelf space to this food that wasn't common in the United States, and it basically only had 20% of its stores that were marketable, and it just was looking for somebody to buy its business for a long time. So management can really make or break the partnership. Now, one partner can typically bind the partnership, and again, that goes back to that statement of authority as to who can do that. All right, now we're on to the next slide. Okay, so some things do require unanimous approval unless it's in the partnership agreement otherwise. So there's the law, and you can change a lot of the law with your specific contract or partnership agreement. So these are just kind of ones that you have to memorize, so I'll let you memorize those on your own. Now, liability in many ways is worse in a general partnership than in a sole proprietorship. Because in a sole proprietorship, you're responsible for yourself and no one else. But in a general partnership, you're responsible for yourself and all your other partners' actions. And that makes it tough because you don't really have a lot of control over anyone but yourself. So this is why a lot of people don't like general partnerships. So the concept of joint and several, SEVERAL, liability comes into play. And what this means is a plaintiff can sue one partner, two partners, all partners, whatever. Whoever the plaintiff sues, if they win the lawsuit, then what happens is the plaintiff can get 100% of the money from those people that he or she sued. And those partners must pay up front. Now, the partners that paid up front can go against the other partners that didn't have to pay anything. But think about this. A lot of times when you sue somebody second, they don't have the money still. So that's not really fair. Then we've got this other concept that is on this slide, and it's called the marshaling of assets principle. And it does help general partners a little bit. It says, we're going to take all your business assets before we go after personal assets. But it still is really heart-wrenching to think about losing all your personal assets potentially just because you wanted to open a business, a small mom-and-pop store, and try to feed your family. All right, continued existence of the business and transferability. So there usually has to be unanimous approval in order to sell to a new partner. And think about this. I mean, it's kind of like a marriage in some respects, at least in terms of money. And you want to have the right to pick who you do business with. So it should be unanimous. All right, profits and losses. Okay. the items that the partners contributed, such as property or cash, is owned by the partnership. But they're hoping to get some money out of this business. Each partner has an interest in those profits. And under RUPA, they would be divided equally. Now, the partnership agreement can go ahead and determine it to be 25%, 75%, whatever. You can change RUPA under the partnership agreement. Okay, sharing in the profits. Again, I cannot stress that no matter how much you put in, you're going to get an equal amount out unless it's written otherwise. So I like to test on that, so make sure you're getting this concept. 4 partners, and one puts in 5%, another one puts in 25%, another one puts in 25%, and one puts in 20%, unless they have some sort of other agreement, then they're all going to get 25%, even though one put in 5%. Now, typically partners don't get set salaries unless it's stated in the partnership agreement. So this is something we also have to ask our clients and see if they want. Now, a great example, somewhat famous, of a general partnership that went bad is if you've ever seen those 1-800 call a lawyer ads that are on at 2 a.m. in the morning or all day during the hours of 8 to 6. It seems like, heck, they're on all the time. Okay, so if you've ever seen mesothelioma, call now to reserve your legal rights, then you've probably seen an ad by Jacoby and Myers. And they had 3 partners, and it was Jacoby, Koff, and Myers. And typically, if they didn't have a written agreement, they should each get 1/3 of the profits. Well, quite famously, Jacoby and Myers decided to cut out the woman, Koff, later on. But before that happened, Jacoby was not getting paid, and he was mad. And he wanted to see the partnership books because he wanted to see how much the partnership was making and how much he was owed. A lot of times partnerships will have fights about getting to see the financial records. Okay. And the partners, Jacoby and Koff and Myers, had the responsibility to make sure Jacoby was getting paid. Okay, next slide. All right, there's a difference between a partnership interest and a right to profits. So the interest is in the partnership property, and so when the partnership ended, what percent of the property do you get, what percent of the building, that sort of thing. A right to profit is what percentage of the profits of the partnership's making do you have, and do you have a right for that being distributed to you on a 6-month basis, monthly basis, whatever the partnership agreement talks about. Okay, so if the general partnership has losses, this slide talks about what to do in that instance, so you can read that one on your own. It's pretty self-explanatory. I like to just discuss the slides with you that need some more explanation. All right, so a partnership also has pass-through taxation, which means that they only have to do taxes through the partners, not the actual partnership. The partnership has to file a form, but it doesn't pay taxes. So the taxes pass through to the partners. And the partners do their own individual tax return, and then they add a schedule to that for the partnership profits and losses. And that's usually easier than doing a corporation taxes. So sometimes people do prefer that aspect of a sole proprietorship or general partnership. Okay, termination is also another slide you can read on your own. Okay, and it goes into the difference between terminating under UPA and terminating under RUPA. And we're going to stick with RUPA because there's very few states left with the UPA, and that's going to be pretty much gone soon, I think. But disassociation is when one partner leaves the partnership, and dissolving is when the whole partnership ends. And thank goodness under the revised Uniform Partnership Agreement, disassociation does not mean the partnership has to dissolve. As long as that partner that's leaving has been bought out, then basically that company, or excuse me, that partnership can continue. A lot of times partnerships will dissolve because they're not making any money. Alright, a joint venture is basically smaller in scope than a general project. So it would be like for one building up one strip mall instead of many different strip malls. Thanks for listening. Talk to you soon. Bye.